let's take a minute to have a little introduction of panel members, and the best thing is if they could tell a little bit about themselves. Sonia, she's a partner in Kirkpatrick Townsend and Stockton LLP, a great law firm here. And Sonia, would you tell what are you doing?
Sure. Good afternoon. As Nishit said, I'm Sonia Baldia. I'm a partner at the law firm Kilpatrick Townsend in Stockton, which is a general practice firm here in the U.S. About 700 lawyers and 17 offices in the U.S. and overseas. It's the firm is general practice, but it's particularly known for its IP expertise. As with respect to me, I'm a technology and an IP lawyer, and my practice basically focuses on technology transactions, IP transactions, and cross-border transactions between U.S. and India.
Thank you. And Gisul?
Hi, yes, I'm Gisu Rafat. I'm one of two employment attorneys for Visa globally, and primarily focus on U.S. as well as Asia Pacific region, which includes India, and have worked very closely with the firm Nishi Desai on a number of employment matters. So
She doesn't need visa anywhere. She has it. Gauri?
Yeah, hi, this is Gauri. I had the IP practice at Nishit Desai Associates. On the industry side, I focus on technology, media, telecom, and pharma. And also, just like Sonia, do a lot of IP transactional and TMT and pharma transactional work and litigation as well. Oh, sorry, okay.
Yeah. Steven. Thank you.
Thanks. I'm Stefan Eberly. I'm with Silicon Valley Bank. I've been there for about 15 years. I'm Assistant General Counsel, and my focus is, part of my focus is our global legal activities. I'm responsible for all of the work that we have done in India, working with Nishit Desai, setting up our entities in Bangalore and Mumbai, and we recently actually sold the one in Mumbai. And also have worked with them and others in Mauritius and other Asian regions. So that's what I do.
Thank you. And Vikram?
Hi, my name is Vikram Shroff. I head the HR law practice at the firm. I'm based in the Mumbai office, and I've been working with a lot of clients, largely multinational companies, and most of them in the US, on various employment and labor law matters.
Great. I think let's start with you, Vikram, right? Last one first. Okay. So what are the structures you've seen for employee transfers and integration in M&A transactions? Or maybe what are the typical issues that arise also under this structure? If you can give a little rundown on that. Yeah. You want to look at the preview? Oh.
Sorry for that. So employment and labor is generally sort of a hot topic when it comes to M&A, especially, several global transactions. Several global transactions that you see, a sort of a M&A that happens in the US has a massive implication in terms of the fact that possibly the largest number of employees that need to be transferred are in India, just because the way technology companies operate, you have a lot of R&D work, a lot of outsourcing work done in India, and those activities are really, well staffed. Several clients I have who are headquartered in the US have their largest number of employees in India, and therefore, this area of law is really given a lot of importance. I mean, and generally, as employees, all of us always thought that we are the most important asset to an organization, especially a services company. That's not what Scott Adams really thought. He looked at it as if that employees are the ninth most important asset. So it's kind of funny, but I can tell you that the importance given on employment matters is really critical, and that's where, when we were talking of diligences and all of that, employee is a whole subject in itself. Can you keep the slides, please? Yeah. Okay, so when you talk of, and I'm just going to take 2-3 minutes, I have a few slides just so that it's easier to kind of, comprehend. different ways to transfer employees in an M&A. In an M&A that where the employees need to be transferred in India, something we call a Section 25FF transfer. It's basically a transfer under labor law. There is something unique to India called a contractual transfer, and then there is a resignation and rehire route, which is an employee transition as against a transfer. Now, each of these modes of transfer of employees have their own sort of pros and cons. For example, if you're transferring employees under law, and you can only transfer a certain categories of employees under law, which are called workmen, and in only certain situations, those workmen are given certain protection under law in case of such a transfer. And basically, there are three important or essential conditions that need to be complied with when you're looking to transfer those employees. The first being service of the workmen is not affected as a result of the transfer. The terms and conditions post-transfer are not less favorable to the employees. And basically, as a result of the transfer, there will be recognition of previous years of service for the purposes of severance and retirement benefits. And if any of these three conditions are not met post the transfer, it basically triggers a notice and severance payout to those employees. So it's critical that when you're looking at a transfer under law, these three conditions are complied with by the buyer. Currently, one of the big issues from an employee transfer perspective in India is whether there is a need for employee consent at the time of transfer. And there have been quite a few judgments on this particular area of law, judgments being on both sides. And the current, and I won't go into the details, but the current thought process is that the employees cannot stop the transfer, from a sort of corporate perspective, but their consent would be needed if you need to transfer them from the seller to the buyer. The other is the employee transition, which is a resignation and rehire. And currently, we are facing just as an example, we are facing a case where even though the employees were, voluntarily resigned and accepted a new employment offer from the buyer, the employees have chosen to challenge the voluntary resignation on their part, by suing the seller. And they've gone to the labor commissioner just to say that they were forced to resign. So again, you have to be careful in terms of, how you're going to structure the resignation. And obviously, in situations where employees do not voluntarily resign, and you want to terminate, the labor laws in relation to termination would apply. And if you're not complying with those labor laws, India doesn't really have an at-will employment regime. And if you don't comply with those labor laws, again, there would be certain implications. And finally, the biggest issue from an employee transfer perspective in India is gratuity. That's something similar to severance, but kind of unique to India, as to the fact that if employees have completed a certain period of a length of service at the time of employment termination, they're eligible to gratuity under law, under a law called the Payment of Gratuity Act. And this is really the most critical condition that employees really look for to ensure that their gratuity benefits does not get compromised as a result of the transfer, because gratuity is linked to the number of years of service. So that's,
Okay.
yeah.
So, Gisu, I think you have some experience, right, on this subject on India. Can you just share your experience?
Sure, absolutely.
Sorry,
Is this on? Can you hear me?
you can use the microphone probably,
Yeah.
or
Yeah, you can hear me okay?
yeah.
So, yeah, I mean, I think Vikram really highlighted sort of the legal issues, and what I can share is a little bit of perspective in terms of really practical considerations that you may want to think about when you embark upon these changes. And a lot of it, from an employee experience perspective, has to do with communication. So these employees, for example, are going to be receiving correspondence or asked to be signing documents, and understandably may feel a little bit nervous around what this may mean, whether it economically or even from sort of a brand perspective. So, working for a company like Visa is something that I think a lot of our employees, both here and in India, are proud of. But if you're changing if you're changing an entity, for example, and you're transferring them from one entity to another, and all of a sudden they're going to be employed by a company of a different name or that looks different, you know, they still want to be able to say they work for Visa. And so you want to sort of think about those things when you're thinking of the entity name that you're setting up, or how you're communicating to employees about who they're employed by and what they can represent to their families and to their community about who they're employed by. And then I think the other really important factor, particularly for larger companies, is the importance of coordination and communication internally amongst the various stakeholders. So working with your tax team, working with your HR team, ensuring that language in your corporate agreements align with whatever provisions you're putting in the either transfer letters or in the employment agreements, to ensure that there is alignment. And that goes both internally and externally. Vikram is not paying me to say this, but I will say that having him as a partner and allowing them to partner then with our corporate lawyers who are working on the commercial agreement side was really important in terms of quickly navigating the changes that we were trying to implement. And again, that's effective communication and collaboration, I think, go a long way in making these things sort of happen quickly and smoothly without any sort of employee relations hiccups or other types of fallout.
Thank you. Stephen, you have, as a multinational company, what are the practical issues you have seen and what one should be mindful of? You know, if company has to terminate employee, for cause.
A lot of the issues that you need to deal with in India or elsewhere are very similar to what you need to deal with in the United States. When you're dealing with the termination for cause, especially in India, one of the key things is to really quickly find out, what the facts are. And it sounds pretty obvious, actually, facts and the operative agreements that apply to the employee. And again, it sounds obvious, but a lot of the times, if you're not careful, the facts are a bit confused, unclear. Records aren't necessarily kept very, very well, and the agreements at times, unless you're very diligent all the way through the relationship with your employees, they sometimes aren't very crisp. Now, luckily, ours have been, because we've had a global focused HR team that has been very good about training people. But I have some friends who've dealt with, who work for multinationals who have a large Indian presence, and they either acquired a company that didn't have a very disciplined approach to documenting things with their employees. And when something popped up where they thought there was cause, the facts weren't clear or well documented. So right out of the gate, you want to collect information and documents and work with your counsel to make sure you know what you have when it comes to obligations and rights as the employer and what the employees have, as well as kind of what happened. Once you've figured that out, if you believe you have cause to terminate someone, there's a couple different things you can do, and it in part depends on what you're terminating someone for. If it's something that's very egregious and you need to get them out quickly, you have to do what you need to do very quickly to get them out, and be very careful about what they've got with them. For example, access to technology and systems. You have to close that off very fast. If it turns out it's something where someone is just not fitting and it's not something egregious, one of the things you can do, and because you want to be sensitive about terminating people, where you can avoid making a big issue both for you and for the employee, you can talk to them about resigning, and resigning with the equivalent of some sort of negotiated severance. And that helps both the employee, because they don't have on their record that they got terminated. It helps the company because it usually helps with a more efficient and clean separation, and also at times can avoid the company having to go to the local government and then doing some filings associated with terminating an employee. And when everything kind of goes wrong, and occasionally it does, grab your attorney and ask him to real quickly come in and help you, because one of the things that's important is as things get contentious or confused, having that attorney-client privilege to help you have open conversations and develop a strategy for how to separate with an employee, with whom you're having problems. That's very important, because you need to have a trusted advisor, whoever you're using, to guide you so that you don't inadvertently make mistakes or do things or say things that will be taken out of context if they're not privileged.
Thank you. I think let me turn to Sonia for a moment. You can tell us how important is IP for the U.S. company in India-focused M&As, and what issues you think are most critical?
Sure. So I'll start with the first one. How important is IP in U.S. M&A of Indian targets? Allow me to deflect that question to the audience. I just want to see how many of you think IP is critical or at least plays an important role in U.S. companies targeting Indian companies.
Yeah, I
How
can.
many?
Yeah.
Yeah, okay. So by a show of hands. All right, so quite a few here, but some uncertainties or some not so sure. Basically, I agree with what some of you think, some of you basically have communicated with your hands, which is that I think IP is playing a very critical role in U.S. buyers looking at Indian targets. And in fact, in recent transactions, more so, what we have seen is that in recent transactions, IP is often the most significant asset in an acquisition or in a transaction that is contemplated by the U.S. company. So to say, the heart of the transaction, and often drives the business terms, the deal structures, as well as the valuation of the target company. So clearly IP is playing a very critical role, increasingly playing a very critical role, and that we see more so in the IT space as well as the IT enabled services space, where we see a lot of technology growing or coming out of India. And that is also because I think the catalyst there was the maturity of the Indian IT services industry. And so that is a very ripe area where we see a lot of U.S. buyers interested in investing. That's quite a significant mind shift, I would say, compared to the historical or the traditional role IP played in M&A transactions previously, where typically IP was viewed as a risk factor, to determine what was the exposure to liability of the buyer, or even if the seller had the right IP to operate its business. It was more of a risk analysis. But I think there is a significant shift now. It's more of a differentiator. I mean, US buyers are looking at Indian companies and saying, hey, I want to acquire this particular technology because it's going to make a difference in my global product strategy, or it's going to somehow add to my competitive advantage. And we're seeing that focus more and more, where IP is the driving factor. And we're also seeing, transactions where IP may not be the key driving factor, but perhaps it is a second or third critical factor that supports the transaction. And I think that typically comes up in pharma or consumer products sector transactions, where, for example, a U.S. buyer might be looking at a pharma target in India for manufacturing capability or for market access, but their IP would nonetheless be a very important consideration for branding purposes, for example, or the proprietary manufacturing processes that are required to optimize their manufacturing. So in short,
absolutely, I agree with you. I think especially these issues we have also seen in pharma, healthcare sector. We just had one case, one of our clients, private equity fund. What happened was that they, somebody approached. He was CEO of one of the former companies in which healthcare and hospitals were being set up. So for that, the former company had done all the studies and surveys and stuff like that. He took the same numbers, same everything, and copied and presented as his own personal plan to the private equity fund. Now, story begins. These people are just putting some money, and a criminal complaint is filed by the former employer because he stole the data, and entire thing became a criminal case. It became very, very important because now even under Information Technology Act also there are certain situations where data theft, is considered criminal. And it was a big issue, and the whole private equity fund, it was a new fund, first deal, and we had a big issue out of that. I won't go in detail, but to deal with criminal process is very tricky, not only for the person who stole the data, but also for the person who alleged, and how to defend the whole thing. So it is very important. Gauri, maybe you may have something to say on this subject as to the IP issues that you have seen arising, and in relation to ownership, chain of title and stuff like that. If at all you find something, how do you mitigate the risk?
Sure. So as Sonia was mentioning, I think what we have noticed is in the Indian context, earlier it was more of a, when you said IT, it was more services-driven organizations, but now it's moving more towards product-driven, and we already have about almost 150 startups coming from India this week, and some of them actually are into the product sector, right? So in the product sector, again, the importance of IP, is much more than probably in the services sector. So what we have seen in the Indian context, let me just divide it into, three buckets. One is from a transactional perspective, during the due diligence, what we notice, what are the exchange control and what are the tax issues. And the last two I will quickly touch upon, but I will more focus on the due diligence aspects. What we have noticed is the IP awareness itself. Few years back, I remember there was a private equity firm who was looking at investing in a particular IT company, and what they realized was that they had not even filed for a trademark application for their software product name. So what it says, I mean, of course, there was not so much value in the name. It was more with the the services and the product, but what it showed was the IP awareness in the company itself. Right, so the most important critical part is how much aware is the company, the management, and the employees. The reason it becomes important, again, in the IT perspective, not everything is patented, right? So most is more of in the trade secret or in the copyright protection that is granted. In India, you don't have a trade secret law, so what you're dependent on the contractual arrangements. So just to give an example, again, non-compete provisions post-termination are not enforceable. We have a current matter where there was an M&A, a foreign company acquiring Indian operations. The employee had non-compete, they adhered to non-compete, but now after 5 years, they have come out with the new company and manufacturing identical products. Now, we are now, doing the complete, due diligence of what were the documents signed. So only when you, start the employment, you may sign a document, but at the time of exit, when, after acquisition, if there are employees leaving, at the time of exit, whether the documentation has been done properly to articulate what exact nature of information that employee, in fact, has acquired. So, all these issues come up quite often. The other important aspect in the Indian context is the concept of work for hire. It is limited only in the employment relationship, not in relation to the consultancy relationship. And you may have, noticed in the IT sector, there are quite a few times you have, workers who are not your own employees, but, taken via, a services company who's providing you with those, the workforce, or you have consultancy relationships. Now, if your contracts are not adequately, covering all the assignment clauses for the IP, I'm not going to too much into detail on that because there are certain other nuances, but the contractual arrangements have to be very, very, clearly done. So what we have actually seen in some, cases is where the documentation was not to the, up to mark. We had to actually tell the target to have all the employees, at least who are in the company at present, to redo the contracts. And sometimes if you have a huge workforce, it becomes a very, very tricky situation. Another interesting thing we have noticed is, for the incubating companies where there are university grants or government grants for, development of the product, the IP policy of the universities and the government are not very clear in India. They are yet not well developed. So sometimes whether the government or the university also has a right in the IP comes up quite often when we are looking at, these incubating companies. And another interesting thing is, what are your internal processes of the target? Whether their processes are sufficient to protect the trade secrets, as I was mentioning earlier. That is very, very important, because if the employees have left and you have no idea who are out there who are going to become your competition. So whether you need to see whether the documentation is up to mark. Another interesting issue in the Indian context is the foreign filing license requirement when it comes to patents. We have seen often in the IP due diligence that the Indian companies have directly filed applications for a patent abroad without filing in India first, or having taken the foreign filing license, which is a requirement. In that context, the applicant, the company and the applicants could actually face a criminal liability. So if you're taking on such a company where the key employees are the ones who may be taken to prosecution, that becomes another exposure. As Huzefa was saying earlier in the earlier panel, in India you don't have litigation searches very readily available. So again, you for IP you need to depend a lot on reps and warranties. Do I continue on exchange control or tax, or do we want to take some other topic?
30 seconds.
Okay, so on the exchange control, very quickly, when you have an Indian IP being transferred outside of India, there are certain timelines within which the money has to come within India. So if you have situations where you have deferred payments or escrow mechanisms, as was being discussed earlier, the Reserve Bank of India approval is required. We recently did one transaction where Indian IP was transferred to Singapore entity, and there were certain payments that were dependent on the profit made by the use of that IP. So we had to file a very detailed application explaining why the payments are being deferred, why is there an escrow, and after which we got the Reserve Bank of India approval. Again, on the tax front, when you're, as was being discussed earlier, you need to do a lot of due diligence as to how the IP is created. Is it homegrown IP or is it acquired IP? Because it may have some consequences when it comes to capital gains tax. And there are a lot of structures that we need to work out, depending upon whether or not there is capital gains tax, and the commercials may change. Again, value added tax for outbound transactions are not applicable. So all these have to be discussed in advance when you're discussing your commercials, so that you need to take those into account, so that later on there are no surprises. So I'll stop here and maybe
Let's have some questions if there are any comments. A little quick.
Yeah, I didn't hear anyone talking about PCTs. I know it's extensive. So we are very used to
Sure.
not only applying within a given time, there's a PCT to be applied.
Right.
And on and on and on. And some countries are not covered in the PCT. Give me some high-level understanding of what the situation is, what are the timelines from provisional to only for Indian. The international, I am
Three
very
experts on that here, at least from our side. Gauri, Webunar, and Shari. And
Yeah.
also Zulfa.
So
maybe
very
Gauri-
quickly, India is definitely a part of PCT convention. In India, for national phase entry, it is 31 months from your priority. And insofar as getting the patent in India, it may take anywhere between 5 to 6 years, unfortunately. You do have provisions where you can file for, additional fee for expedited, publication as well as expedited examination. That becomes relevant again in the technology sector, because the rate of obsolescence is too high, right? So if you have not got your patent within a particular time, somebody is already out there, and you have lost your competitive advantage, right? So in the Indian context, when you are looking at any patent, filings, etc., that is one thing you need to keep in mind, whether you are, actually getting anything out of that or not. So maybe we can talk later about the other aspects on the PCT. Yeah.
Thank you. Okay, I think we can. Yeah. So I think the short point is that, we have regime for almost everything. It's just you need to know about it. Okay, we have too many laws, sometimes more than what you need. But in particular, corporate tax, IP, and a couple of other ones. Those are the major ones that you need to focus on. So I would, for the time being, close it at that. And we would have, again, very short coffee break if you like to have. And then we have very interesting session, last one, the deal terms, exit rights and enforceability. I think this is another important thing that we'll be happy and ready. Thank you so much for interaction.